Hello, free speech and the challenge of social media students. This is Dr. Conway back to you for lesson 3. This lesson tends to be more technical in nature, but it's important information for us to move through so that people can understand that free speech in a liberal democracy, as we discussed in last lesson, is a very important right, and it's very critical right for democracy generally. But there are already in society limitations on free speech that we must protections for, and limitations on free speech, that are in law that we should be aware of before we advance a lot more into our course. It's important for us to understand that the law already draws parameters around the rights and obligations of free speech, and for us to really have an educated conversation of free speech and the challenges of social media, we should at least have a good understanding, or a basic understanding at least, of the legal context of free speech within our country, and within most liberal democracies actually. So in this lesson, the slides go through a number of different technical decisions and rights and obligations that you can read in the slides. I'm not going to reread them for you as we go through, but I want to give you the context, and I want to give you a bit of the flavor of what we're talking about here when we look at these. So in the through the slides, you'll see that there's a human rights approach to free speech. We have free speech rights enshrined in the Canadian Charter of Rights and Freedoms, and which I'm sure many of you have learned about when you were in your high school and your secondary school education. And restrictions on free speech prescribed in law. So we have rights for free speech, but we also have obligations for free speech. That's why I use the terms rights and obligations, and those obligations are prescribed in criminal law. In other words, there are certain speech practices that are not permitted under law, okay, and for good reason. And you notice that the presentation, or the lesson plan, is very clear that not all speech is free, and the reason that I have that subtitle in there is to get across the point that while we have free speech protections in our liberal democracy, we also have obligations to control certain kinds of speech, and those obligations are set out in law. In addition, a lot of people, as you will all know by this point in your lives, there's pressure on the things that are said in free speech in terms of the social norms of our society. Okay, so I don't talk a lot about the social norms of our society right now in this lesson, although we will certainly be talking about this as we go through the course. But this particular lesson speaks to the legal dimensions of free speech in Canada. Okay, so let's start off. There's certain things you have to be aware of course, is that free speech is not just enshrined in Canadian law, but it's enshrined in international legal infrastructure as well. And starting as early as the Universal Declaration of Human Rights, what proclaimed in 1984 by the UN General Assembly, as this common standards, perceived to be a common standard of achievement for all peoples and all nations. The preamble of that declaration states, whereas disregard and contempt for human rights have resulted in barbarous acts which have outraged the conscience of mankind, and the advent of a world in which human beings shall enjoy freedom of speech and belief and freedom from fear and want, has been proclaimed as the highest aspiration of the common people. So even at the preamble of the Declaration, freedom of speech is clearly laid out because of its centrality to all of those things that support democracy, as we've already discussed in our previous lesson of last week. And the Declaration with respect to free speech, Article 19 states, everyone has the right to freedom of opinion and expression. This right includes freedom to hold opinions without interference, and to seek, receive, and impart information and ideas through any media and regardless of frontiers. regardless of frontiers, is obviously an important thing in the context of social media, because of course social media has no frontiers, okay? Unless we have a complete national firewall around the internet in some countries, for example, like we have in China. But it's not the only country that has that, North Korea and so on and so forth, okay? So, and it's interesting that the UN Declaration holds the Guinness World Record as the world's most translated document in over 500 languages. Its original intent was that its provisions be adopted at the national level throughout the United Nations membership. However, as one would expect, the Declaration, with its heavy influence by liberal democracy, was and is resisted by states with authoritarian regimes or tendencies. So whenever we have a temptation to control free speech, we have to contemplate that very, very carefully, because any actions that a liberal democracy takes to curtail free speech will obviously be emulated and multiplied many times over by authoritarian states. And then they will point to liberal democratic states and say, well, if they can do it, we're just doing it in our way. Okay, so this is what, as you recall, I said earlier that the Prime Minister came out quite recently in Canada and said that he's afraid to regulate social media because of the precedent it would set for authoritarian regimes. Okay? So, but, you know, the Declaration has had its pitfalls. In fact, in 2018, the United Nations celebrated the 70th anniversary of the Declaration, but pointing to ongoing threats to human rights. And we know many of these, right? Threats identified by the United Nations at the 70th anniversary of the Declaration include a long list that you can see on the slides that are for this lesson plan, right? And it's very important that we understand that you know, without free speech, the tendency for threats to freedoms will be magnified. There's no question about that. All right. So we need to account for that as we contemplate the narrative of this course as we go forward. Okay. Then we have the Canadian human rights approach. So we had the international approach to protecting free speech, and now we have the Canadian approach to human rights laws, which also were also profiled free speech. Okay. Most human rights laws in federal and provincial jurisdictions across Canada address free speech, and they adopt similar principles, complaint mechanisms, and tribunals established to hear the complaints against human rights. Every law, every one of these laws prohibits discrimination based on sex, race, age, religion, employment, accommodation, and publicly available services. The Canadian Human Rights Act of 1977 is the principal human rights law at the federal level. It applies to the conduct of federal government departments and agencies, crown corporations, and federally regulated businesses. Interestingly, the Ontario Human Rights Code of 1962 was the first such act in Canada. So Ontario was quite progressive on this, all right? But a lot of these things in terms of protecting human rights and protecting rights and freedoms, including the freedom of speech in Canada, were preempted by Canada's Charter of Rights and Freedoms, all right? So what I'm trying to do is give you a sense that there's this international dynamic that's been long-standing on protection of free speech. Then Canadian human rights laws were adopted at both levels of government, federal and provincial, that also included these protections of human rights and free speech. But then came along the patriation of Canada's Constitution and the preeminent role of Canada's Charter of Rights and Freedoms in protecting these rights. Okay, which superseded the Human Rights Acts, okay, for the most part, for purposes of our course, okay. So, in liberal democratic countries, legal infrastructure applicable to the study of free speech is comprised of the written constitution, legislative acts, laws of general application, and interpretations of the courts. I think we all know what the Constitution is, right? We also have legislative acts that influence free speech, both by protecting it and, in some cases, by constraining it. For example, you know, the constraint on free speech in false advertising, for example. All right, the constraints on free speech in freedom of information laws. Like if you give information to the government, they can't freely distribute it. So the point is that there are all kinds of discrete restrictions on free speech, even in a liberal democracy. And the reason those restrictions exist is to protect some other value or some other important objective that the government has and that the people have for protecting people from free speech, okay, or from free distribution of faulty information, or from free distribution of confidential information, and these kinds of things, okay. And then we have the interpretations of the courts have also set a number of precedents for what is free speech and what is a restriction on free speech, all right? But for the purposes from our perspective, the two major factors that we're considering here is the protections in the Constitution of Canada, Charter of Rights and Freedoms, and in the protection of against harmful speech in criminal law, which is a law of general application because it applies to all of us, right? And the criminal law applies to all other legislative instruments, all right? So what is a constitution? Let's just recap. A constitution is the preeminent law of a political system, typically consisting of rules governing the relationship between citizens and the state, okay, and between different parts of the state. Okay, why is that important? Well, constitutions are primarily designed to protect the citizenry from power overreach by government, by the state. All right, that's primarily what a constitution tries to achieve. Protects citizens from their own government if that government power was to be abused. But other elements of the Constitution in Canada, because we live on a federal state, right, where we have the federal government, we have the provincial governments, and each of them have their own constitutional powers, right, is to define the relationship between these levels of government and their respective constitutional powers, okay? In other words, in a country like Canada, the provinces are not the children of the federal government, okay? The municipalities are the children of the provinces, yes, but the provinces and the federal government are distinct governments with their own constitutional powers, okay? So it's important to understand the distinction there, why our Constitution is the way it's shaped. But from our perspective, the most important aspect of constitutional law for us is the protection of the citizen from overreach of the state. Okay, so the Canadian Constitution was patriated from Great Britain in 1982. Okay, it consists of written documents. So something that a lot of people don't realize is the Constitution is more than just the written documents. It also involves court decisions, okay, which set precedent under common law, okay, and unwritten conventions, informal and uncodified procedural agreements that are followed by state institutions, okay. All of these have representation before the courts when there is a dispute over a constitutional right, okay. So together, these constitutional components describe the basis and method by which political representatives are chosen, the scope for legitimate state power, including how it is limited, vis-a-vis citizen rights, collective and individual rights, and of course the Charter of Rights and Freedoms being paramount here. Division of powers in the Canadian Federation between different levels of government, as I just described. Okay, as stated in Lesson 2, the designers of the Charter acknowledge that freedom of expression plays a vital role as an instrument of democracy, truth, and personal fulfillment. And so the Constitution places a great deal of emphasis on protecting these rights and freedoms, of which freedom of association and freedom of speech are particularly important, are one of the most important areas of constitutional protections. Two key articles are essential for understanding the protections and limitations for freedom of expression in Canadian law. Sections 1 and 2. Rights and Freedoms in Canada. Section 1. The Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it, subject only to such reasonable limits as prescribed by law as can be demonstrably justified in a free and democratic society. All right? And I'll get to that a little bit more. What does that mean? You know, is it free or not free, right? It's free subject to certain limits prescribed by law that can be demonstrably justified in a free and democratic society. How do we guarantee that? Well, remember what we talked about elections. And in a liberal democracy, right, the citizens ultimately can withdraw its government and elect a different government, okay? And then fundamental freedoms section 2, okay? Everyone has the following fundamental freedoms: freedom of conscience and religion, freedom of thought, belief, opinion, and expression, including freedom of the press and other media of communication, freedom of peaceful assembly, freedom of association. Okay, so each of those freedoms is protected in the constitutional law, which of course is the highest law of the land, right? And the Constitution is the highest law of the land in a liberal democracy. Okay, but what are the restrictions on free speech? Because we're saying that not all free speech is free, right? Not all speech can be allowed, right? If we want to have a civil society that can function and not be in conflict, right? Or not be oppressive of certain peoples as opposed to other peoples, and so on. So as noted in section 1 of the Charter, limitations may be placed on Charter guarantees subject to those being consistent with a free and democratic society, as I already pointed out. Governments at the federal, provincial, and territorial levels in Canada have imposed restrictions on freedom of expression. For example, under the Criminal Code, speech that is defamatory or libelous, encourages suicide, advances perjury and fraud, and or involves uttering threats against other person or groups are prohibited. There are also restrictions on free speech that are more focused on specific circumstances, such as the case of restrictions on publishing election surveys on a federal election day, to name but one. But there are many, as I've already cited. There are restrictions on false advertising, restrictions on releasing confidential information of citizens to other citizens. There are all kinds of discrete limitations on free speech that exist within various legislative instruments across all levels of government, all designed to protect, while not trying to compromise free speech beyond what is necessary in a democratic society, but also to protect other objectives, like protect people from harm, protect people from fraud, protect people from libel, and so on. All right. With respect to hate speech, the Supreme Court of Canada in a 1990 decision stated a very important decision. Hatred connotes emotion of an intense and extreme nature that is clearly associated with vilification and detestation. Hatred is predicated on destruction, and hatred against identifiable groups therefore thrives on insensitivity, bigotry, and destruction of both the target groups and the values of our society. Note the values of our society, all right? Remember before I talked about the legal requirements, but I also pointed to the values and norms of society, and the courts reflect that, okay? Hatred in this sense is a most extreme emotion that belies reason, an emotion that, if exercised against members of an identifiable group, implies that those individuals are to be despised, scorned, denied respect, and made subject to ill treatment on the basis of a group affiliation. So the Supreme Court basically was taking a stand against hate speech, okay, within the limits of our freedoms for free speech, okay? Similarly, in a famous review, I'm giving you examples here, right? There are other court rulings in other jurisdictions that are similar. But similarly, in a famous review of the Saskatchewan Human Rights Code, Human Rights Commission versus Watcott, the court stated that prohibiting representations that are objectively seen to expose protected groups to hatred is rationally connected to the objective of eliminating discrimination and other harmful effects of hatred. Okay, so in other words, controlling hate speech is a necessary condition for ultimately eliminating hateful actions within our society. Okay, clearly a very clear limit on free speech. All right, in addition to the other things we talked about, like libel, false advertising, and so on and so forth. Okay, in other words, hate is never free. for those who are exposed to it, right? That's one thing we keep, when people say hateful things and we challenge them and they say, they come back and say free speech. And the response that would be a typical response for somebody who understands the concept of free speech in a liberal democracy is to say that hate is never free for those who are exposed to it. All right? So while it may be free speech, the type of speech you're exercising is hate speech, and it's not free. It's very costly to society. Two sections of the Criminal Code of Canada, Section 318 and 319, explicitly addresses anyone who promotes genocide or incites hatred in public. Section 318.1 states that every person who advocates or promotes genocide is guilty of an indictable offense and liable to imprisonment for a term of not more than 5 years. Okay? Section 319.1 states everyone who, by communicating statements in any public place, incites hatred against any identifiable group where such incitement is likely to lead to a breach of the peace is guilty of an indictable offense and is liable to imprisonment for a term not exceeding 2 years, an offense of punishable or summary conviction. Okay? Section 319.2 states everyone who, by communicating statements other than in private conversation, willfully promotes hatred against any identifiable group is guilty of an indictable offense, an offense punishable on summary conviction. All right? So it's very clear that, well, we definitely value free speech in a liberal democracy and need to protect free speech in a liberal democracy because it's core to democracy. We also recognize that there must be, in order to protect civil society, there must be some discrete, justifiable restrictions on free speech. Why do I raise that now? Because this is an interesting conversation for when we get into the manifestation of free speech in social media, where people are sitting behind their monitors perceived to be anonymous and are saying things in their computers that they would never say in public or face to face. All right? And this is a major challenge of social media, right? The ability for anonymity in speech. How does one enforce these laws in that context, right? It's a very difficult question when we're dealing with free speech in its new dimension, which is free speech in social media. So balancing free speech with anti-hate laws, okay? Because of the importance of free speech to democracy, the Government of Canada has taken pains to make sure that anti-hate laws are also not abused. For example, Section 318.3 states, no proceeding for an offense under this section shall be instituted without the consent of the Attorney General. Why do we do that? Well, because of the value placed on free speech in a liberal democracy, we need to make sure that the controls on free speech are not unjustified, that they are in fact reasonable in the context of a liberal democracy. Okay, this provision was intended to defend against abuses that could arise from the use of the law to unnecessarily constrain free speech in a free and democratic society. Similarly, Section 319.3 states that no person shall be convicted of an offense under Section 2 if he establishes that the statements communicated were in fact true. Okay? They were factual, because then you're reporting a fact. Okay? If in good faith the person expressed or attempted to establish by an argument an opinion on a religious subject or an opinion based on a belief in a religious text. In other words, if your opinion is based on a religious text or a religious subject, right, then there's going to be a lack of willingness for the state to proceed with any legal proceedings. If the statements were relevant to any subject of public interest, this discussion of which was for the public benefit, and if on reasonable grounds he or she believed them to be true. Or D, if in good faith he intended to point out for the purpose of removal matters producing or tending to produce feelings of hatred toward an identifiable group in Canada. In other words, they were referring to something else. So under these conditions, the state would be highly reluctant to proceed with any kind of a criminal prosecution of that speech. All right. So even where we criminally, we have controls on hate speech and other harmful speech within criminal law, the liberal democratic societies have been very cautious to allow for protections so that those criminal laws, those laws against that curtail free speech are not abused, right? And that again speaks to the vital importance of free speech to a liberal democracy, correct? Section 319.6 also states, no proceeding for an offense under Section 2 shall be instituted without the consent of the Attorney General. Again, back to the politically elected people, and for the senior officials to make sure that there are no abuses of laws restricting free speech. Okay. And then the role of the courts also have as fundamental. If there's a dispute between whether a prosecution of a harmful speech was to take place, the courts will ultimately decide based on the Constitution, previous decisions and conventions, and so on, as we discussed earlier, with respect to what comprises the decisions that a court would, or what pieces of information that a court would use to make a decision. Okay, section 17.2A1 of the Criminal Code sets out various principles for sentencing if an incitement incidence of hate speech has been found. This section allows for increased penalties when an offender is sentenced by the court for any criminal offense motivated by bias, prejudice, or hate based on race, national or ethnic origin, language, color, religion, sex, age, mental or physical disability, sexual orientation, or gender identity or expression, or any other similar factor. So the courts can decide to adopt a penalty that suits the crime, basically. Okay, but the courts will also interpret whether rights have been abused, or whether criminal law has basically been taken too far in suppressing free speech. So yes, there are restrictions on free speech in law, but there are also a number of protections to make sure that those restrictions are not abused, which is entirely consistent with the importance of free speech to a liberal democracy. And in Canada, these are some of the factors. Now, when you take this institutional legal reality into the social media environment, things start to break down. How do you enforce these things in a social environment context when the speech may be coming from Russia or some other country in Latin America, or some country in Asia, or whatever? How do you enforce these, right? So what's happened with free speech in the social media context is the controls we had when speech was largely local, right? Before, when we would get a lot of our information from newspapers, well, you knew where to go get them if they were breaking the law, right? In terms of hateful speech or other forms of speech. If it was a domestic group, using traditional channels of communication, you knew where to find them, right? If they were average citizens on the street, or they formed a group and were putting up on telephone poles hateful banners or something, you knew where to go to find them. Where do you go to find this kind of hateful speech and this kind of harmful speech, and when you're living in a globalized social media environment? And that's the reason I wanted to take you through these laws. At what point do we have to conclude that some of the laws that now protect us against harmful speech are almost impossible to enforce outside of our borders, right? It presents very interesting discussion points for, what is, how has the norms, the laws, the constitutional decisions of the past and so on, how do they apply to the new context, right? How do we maintain a free speech environment in a social media context that captures the benefits of free speech to democracies and to people, but mitigates the harmful aspects of speech in that context? As I said, prior to the social media environment, we were largely able to do that because most of the speech was local, or certainly most of the speech that the average young person growing up, let's say when I was growing up, most of the information we would have received would have been from traditional channels, okay? They would have been from the media, from local NGOs putting up banners or releasing leaflets or pamphlets or documents of various kinds, all of which it was very easy to determine the origin. And most of the times the origin was local, or it was another democratic G7 country. It was the United States, or it was Europe, or whatever, right? But now suddenly we have free speech that is ballooned to all these anonymous entities around the planet, that, in a way that, how do you control the harmful aspects of free speech while you're trying to capture the beneficial aspects of free speech? And it's important to see this legal infrastructure as being challenged by this new phenomenon of the massive explosion of social media and the globalization of communication, and where our laws begin to look unfit for duty, okay, in terms of responding to all of these challenges. Okay, on that point, I'll let you go. I'll be back for lesson 4, obviously. Keep working, gang. Keep working on the course material, and I'll be back to you soon. Take care for now. Bye-bye.